Have you ever wondered what would happen if a federal court suddenly decided that one of the most common requirements attached to carrying a firearm in America was never constitutional in the first place? Not next year. Not after another decade of appeals, right now. Because that is exactly the scenario unfolding today. And the reason millions of gun owners, state lawmakers, law enforcement officials, and constitutional attorneys are paying close attention. A federal court has issued a ruling that could fundamentally alter how firearm carry laws operate across a large portion of the United States. What makes this case extraordinary is not simply the outcome. It is the fact that every judge on the panel agreed on the core constitutional issue. No split decision, no narrow majority, no ideological deadlock, just a clear ruling that has left state governments scrambling to figure out what happens next. And yet, despite the potential impact on millions of Americans, most people have no idea this case even exists. The headlines barely mentioned it. The major networks moved on almost immediately. But the legal consequences of this decision could be felt for years. And by the end of this video, you will understand why constitutional scholars are calling this one of the most significant Second Amendment developments in recent memory. The case began when a coalition of gun rights organizations challenged the very foundation of the modern permitting system. Their argument was surprisingly simple. They claimed that a constitutional right should not require government permission before it can be exercised. According to the plaintiffs, the right to bear arms belongs to the people by default, not because a state government grants it, but because it is protected by the Constitution itself. They argued that forcing citizens to apply for approval, pay fees, complete bureaucratic processes, and wait months for government authorization turns a protected right into something that functions more like a licensed privilege. The court was asked to answer a question that goes far beyond firearms. Can the government require citizens to ask permission before exercising a right that already belongs to them? That question became the center of a legal battle that ultimately produced a ruling capable of reshaping how firearm regulations are viewed throughout the country. What makes the court's reasoning so important is that the judges did not simply look at modern public policy arguments. They examined the historical foundations of the Second Amendment itself. They looked at how firearm regulations were understood during the nation's founding period. They analyzed historical traditions, early American legal practices, and previous Supreme Court precedents. After reviewing that history, the court concluded that many aspects of the modern permitting framework extended beyond what could be justified under the constitutional standards established by recent Supreme Court decisions. In practical terms, the judges were saying that while governments may regulate firearms in certain circumstances, they cannot impose burdens that effectively require citizens to seek permission before exercising a fundamental constitutional right. That distinction may sound technical, but it has enormous real-world consequences. For decades, many Americans have accepted the permitting process as simply part of life. If you wanted to carry a firearm legally, you filled out the paperwork, paid the fees, submitted fingerprints, completed training requirements, and waited for approval. Some states made the process relatively straightforward. Others made it so complicated and expensive that many applicants simply gave up. In certain jurisdictions, people waited months or even longer for permits to be processed. Supporters of these systems argued they were necessary to ensure public safety and prevent dangerous individuals from carrying firearms. Critics argued that the systems were often used to discourage lawful citizens from exercising their rights. This ruling directly challenges that entire framework by asking whether constitutional rights should depend on government approval in the first place. Think about it from a broader constitutional perspective. Imagine if you needed a government-issued permit before attending a political rally. Imagine if you had to submit fingerprints, pay a fee, and wait several months before publishing an opinion online. Imagine needing official approval before attending a religious service. Most Americans would immediately recognize those requirements as unconstitutional because rights are generally presumed to belong to the individual, not granted by the government. That comparison became one of the most powerful arguments presented during the case. The plaintiffs argued that the Second Amendment should be treated with the same level of constitutional respect afforded to other fundamental rights. Whether someone agrees or disagrees with that argument politically, it is becoming increasingly influential in courts across the country. The immediate impact of this ruling is creating enormous uncertainty because states now face a difficult choice. Some will likely accept the decision and begin rewriting their laws to comply with the court's reasoning. Others are expected to fight aggressively through appeals and new legislation. In fact, legal analysts are already predicting a wave of state-level responses designed to preserve as much regulatory authority as possible while attempting to remain within constitutional boundaries. This is where the next phase of the battle begins. Lawmakers understand that simply renaming an old restriction will not necessarily save it from constitutional challenge. Courts are increasingly willing to examine the actual effect of a law rather than merely accepting the label attached to it. If a state eliminates a permit requirement but replaces it with a different process that produces the same result, judges may view it as an attempt to circumvent the ruling rather than comply with it. The ripple effects extend far beyond permits themselves. Once a court establishes a principle that government approval cannot be required before exercising a constitutional right, attorneys immediately begin applying that principle to other regulations. Training mandates, waiting periods, licensing fees, registration systems, and location-based restrictions could all face new scrutiny. Every regulation that imposes a burden on firearm ownership may eventually be tested under the same constitutional framework. That is why legal experts are describing this decision not as the end of a legal battle, but as the beginning of a much larger transformation. The ruling does not simply affect one policy, it potentially affects the legal reasoning supporting dozens of policies nationwide. Perhaps the most important thing to understand is that this case is not really about paperwork. It is about who carries the burden of proof. Under many traditional permitting systems, citizens were required to prove they deserved permission to exercise a right. They had to demonstrate eligibility, justify their need, and satisfy government requirements before receiving approval. The court's ruling moves in the opposite direction. It suggests that rights belong to the citizen by default, and that the government must justify restrictions rather than citizens having to justify exercising their rights. That may sound like a subtle distinction, but in constitutional law, it changes everything. It affects how future cases are argued, how judges evaluate restrictions, and how lawmakers draft new legislation. The reality is that nobody knows exactly where this legal transformation will ultimately lead. Appeals are coming. New lawsuits are already being prepared. State legislatures are drafting responses. Advocacy groups on both sides are mobilizing resources for what could become years of litigation. What we do know is that the legal landscape surrounding the Second Amendment is changing faster than it has in generations. Whether you support stronger gun rights, stronger regulations, or something in between, understanding these developments has never been more important. Because while politicians debate the issue and television networks chase the next headline, the courts are quietly making decisions that could redefine constitutional rights for millions of Americans. And this ruling may end up being remembered as one of the moments that changed everything. What happens next is where this story becomes even more important. Most people hear about a court ruling and assume the issue is settled. They think the judges made a decision, everyone follows it, and life moves on. That is not how constitutional battles work in America. In reality, the ruling itself is often just the beginning. The moment a major decision is handed down, lawyers on both sides immediately begin planning their next move. State governments start looking for alternative ways to achieve the same policy goals. Advocacy groups begin searching for new cases that can either expand or limit the scope of the ruling. Federal judges in other jurisdictions start reviewing their own pending cases through an entirely different lens. What appears to be a single decision quickly turns into dozens of legal battles unfolding simultaneously across the country. That is exactly what is happening here, and it is why legal experts believe the full consequences of this ruling may not be understood for years. One of the biggest questions now facing lawmakers is whether they can preserve the practical effects of the old permitting system without technically calling it a permit system. That might sound like a strange question, but it happens all the time in constitutional law. Governments often respond to unfavorable court decisions by rewriting regulations using different language while attempting to preserve the same outcome. The challenge is that courts are becoming increasingly skeptical of that approach. Judges are no longer focusing only on what lawmakers call a regulation. They are focusing on what the regulation actually does. If a state eliminates a permit requirement but replaces it with a mandatory approval process that takes months to complete, requires expensive fees, and allows officials broad discretion, many courts may conclude that nothing meaningful has changed. In other words, simply changing the label may not be enough. The legal question becomes whether the new system functions differently or merely disguises the old one. This is where the issue becomes much larger than firearms. The principles being debated in this case touch on the relationship between citizens and government itself. At its core, the argument centers on a simple but powerful idea. Do constitutional rights belong to individuals automatically, or do governments have the authority to place conditions on how those rights are exercised? Supporters of the ruling argue that rights are protections against government interference, not activities that require government approval. They believe that once a right is recognized as fundamental, the burden should fall on the government to justify restrictions rather than on citizens to justify exercising the right. Opponents argue that modern society presents challenges that did not exist centuries ago and that governments must retain flexibility to address public safety concerns. The tension between those two viewpoints is driving much of the legal conflict we are witnessing today. What makes this debate especially significant is that recent Supreme Court decisions have increasingly emphasized historical analysis. Courts are now being asked to examine whether modern regulations have meaningful historical parallels dating back to the nation's founding period. That requirement has transformed how Second Amendment cases are argued. Instead of debating whether a law is a good idea, attorneys are often debating whether similar restrictions existed during the late 18th and early 19th centuries. This shift has placed governments in a difficult position because many modern firearm regulations were created relatively recently. Finding historical examples that closely resemble today's laws is not always easy. As a result, regulations that seemed secure for decades are suddenly being forced to survive under a much more demanding constitutional test. The uncertainty created by this shift is already having real-world consequences. Law enforcement agencies are closely monitoring developments because changes to carry laws affect how officers interact with the public. State governments are reviewing enforcement procedures. Prosecutors are reassessing ongoing cases. Citizens are trying to understand what rights they possess today compared to a year ago. The confusion is understandable because legal transitions rarely happen overnight. Even when a court issues a major ruling, questions remain about implementation, enforcement, and future appeals. That uncertainty creates an environment where misinformation spreads rapidly. Some people exaggerate the impact and claim every firearm regulation has suddenly disappeared. Others downplay the ruling and pretend nothing has changed. The truth lies somewhere in between. Significant legal changes are occurring, but the exact boundaries of those changes are still being defined. Perhaps the most fascinating aspect of this entire situation is how quickly momentum can build once a major constitutional barrier falls. Attorneys who spent years waiting for favorable precedent suddenly find themselves with new opportunities. Cases that seemed unlikely to succeed may now have a path forward. Legal theories that once existed only in academic discussions can suddenly become the foundation of serious litigation. That momentum tends to create a domino effect. One ruling influences another. One successful challenge encourages several more. Before long, courts are confronted with a wave of related cases, all asking variations of the same fundamental question. We are beginning to see that process unfold now, and it is one reason many legal observers believe the next few years could produce some of the most important Second Amendment decisions in modern history. At the same time, supporters of stricter firearm regulations are not standing still. They understand exactly what is at stake, and they are already adapting their strategies. Instead of focusing solely on permits, many are exploring other areas where governments may still possess broad regulatory authority. Issues such as safe storage requirements, prohibited persons laws, mental health restrictions, liability standards, and enforcement mechanisms are likely to receive increased attention. In other words, even if one battlefield changes dramatically, the broader debate continues. Constitutional conflicts rarely disappear. They evolve. They shift into new areas. They adapt to changing legal realities. What we are witnessing is not the end of an argument, but the beginning of a new phase in that argument. And that may be the most important takeaway of all. This ruling is not merely about permits, paperwork, or administrative procedures. It represents a deeper struggle over how constitutional rights should be understood in the 21st century. The courts are being asked to define the limits of government authority, the scope of individual liberty, and the balance between public safety and constitutional protections. Those questions are not going away. In fact, they are becoming more important with every new lawsuit, every new appeal, and every new ruling handed down by the courts. The legal landscape is changing, and whether people realize it or not, the decisions being made today could shape the rights and responsibilities of future generations for decades to come.